Welcome to our deep dive on whether you truly need an immigration lawyer for a straightforward B-2 visitor visa, especially when inviting an elderly family member for a short stay. In this video, we will provide clear, step-by-step guidance, discuss when legal help becomes essential, and show you how to strengthen your application effectively. Let's begin by outlining the agenda to keep you oriented. Here's our roadmap for the video. First, we will cover the hard truth behind B-2 visas. Next, we will walk through the process and typical pitfalls. After that, we will identify scenarios where legal counsel is essential. Then, we will show you how to demonstrate strong ties abroad. We will also cover how to properly vet an attorney and adopt a cost-benefit mindset. Finally, we will test your understanding with quick quizzes and wrap up with a concise checklist and summary. The hard truth is that for clean, straightforward B-2 visitor visa applications, hiring an immigration lawyer is often optional. The core task is proving non-immigrant intent through strong ties abroad. However, the presence of red flags such as prior denials, overstays, or criminal records drastically changes the calculus and can make professional legal counsel essential. With that context, let's move to a quick visual of the process to ground our discussion. Let's walk through the B-2 process. You complete the DS-160, pay the MRV fee, schedule the interview, prepare your documents, and then attend the interview where a decision is made. Under U.S. law, every applicant is presumed to be an intending immigrant until they demonstrate otherwise. Therefore, for an elderly relative, the main focus is proving they will return home after their visit. Documentation supports your claims, but the most important element is a consistent, credible explanation of purpose and ties. If refused under 214B, it generally means the officer was not convinced of non-immigrant intent, and you must reassess the strength of your ties before reapplying. Now let's dive deeper into what presumed immigrant really means for you. Under the presumption of immigrant intent, visa officers begin with the assumption that an applicant intends to immigrate. Your job is to rebut that assumption by demonstrating strong, binding ties to the home country. Common examples include property ownership, ongoing employment, family responsibilities, and financial obligations. For elderly visitors, emphasize their home base, daily routines, social and community ties, and any caretaking roles that anchor them. Consistency is critical across your explanation, your documents, and your travel history. Next, we will compare when do-it-yourself may suffice versus when an attorney is warranted. Here is a side-by-side comparison. Do-it-yourself is appropriate if the applicant has a clean history with no prior denials or overstays, a clear and short travel purpose, strong and documentable ties, and straightforward finances. In contrast, hire a lawyer if there are prior denials or revocations, any overstay or status violation, any criminal record, complex medical issues requiring waivers, or complicated financial or sponsorship circumstances that require careful legal framing. Moving forward, let's visualize the application timeline and key checkpoints to keep your preparation on track. This timeline illustrates each stage from the decision to apply through the interview outcome. At the DS-160 stage, accuracy and consistency are paramount. When paying the MRV fee and scheduling, ensure appointment details match the DS-160. During document preparation, gather evidence of ties and financial support. On interview day, concise and consistent answers are crucial. At each checkpoint, if you encounter red flags such as a prior denial, a past overstay, or complex medical history, that is where legal counsel may be advisable. Now, let's pinpoint exactly when a lawyer becomes essential. Legal counsel is essential if any of the following apply. First, prior visa denials or revocations. Second, any history of overstaying a U.S. visa. Third, any criminal record, regardless of how minor or how long ago it occurred. Fourth, serious medical issues that may require waivers. And fifth, complicated financial or sponsorship arrangements that need careful legal explanation. Next, to give you a quick reference, here is a table linking red flags to why they matter. This table links common red flags to the risks they introduce and typical responses. Prior denials raise doubts about intent or eligibility, requiring a direct response and often legal review. Overstays create credibility and compliance concerns, which may trigger inadmissibility issues. Criminal records can create inadmissibility risks, and require legal analysis and potential waivers. Serious medical issues can raise public charge or waiver needs, again warranting counsel. Complex finances can appear inconsistent and benefit from professional framing. Now, assuming your case is clean, let's move to practical steps to demonstrate strong ties. Follow these steps to demonstrate strong ties. First, assemble identity and civil documents. Second, gather proof of ongoing life at home such as property documents, leases, utility bills, and bank statements. Third, collect employment evidence including a contract, employer letter, pay slips, and an approved leave letter. Fourth, document family ties and caregiving responsibilities. Fifth, include community indicators such as club memberships or regular medical appointments. Sixth, outline a short, focused itinerary and obtain a round-trip booking on hold along with a host's invitation if applicable. Seventh, prove financial sufficiency through bank balances, pension letters, or a sponsor's affidavit of support if used. Finally, conduct a consistency check across your DS-160 documents and the narrative you will present. With the basics covered, let's visualize what officers weigh most during interviews. This pie chart illustrates approximate emphasis areas during a typical B-2 interview. Home ties receive the largest weight, followed by the clarity and credibility of your trip purpose, then financial sufficiency, then travel history and compliance, and finally, other minor factors. While exact weights vary by case, prioritizing home ties and a credible, narrow purpose is a smart strategy. Next, let's test your understanding with a quick quiz. Question: for a clean, straightforward B-2 visitor visa case, do you generally need to hire an immigration lawyer? Options are A. Yes, always. B. No, rarely necessary for clean cases. C. Only if the applicant is elderly. D. Only if the sponsor is a U.S. citizen. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. For clean cases, hiring an immigration lawyer is rarely necessary. Attorneys are most valuable when issues such as prior denials, overstays, criminal records, medical waivers, or complex finances are present. Let's move on to another quick check. Question: what is the primary hurdle for an elderly B-2 applicant to overcome at the interview? Options are A. Paying the MRV fee. B. Demonstrating strong ties to the home country. C. Showing a 5-year itinerary. D. Bringing notarized letters from neighbors. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. The key hurdle is rebutting the presumption of immigrant intent by demonstrating strong ties to the home country through credible, verifiable evidence. Now, let's ensure you know how to vet an attorney if you do need one. To vet an attorney, first verify certification and look for membership in reputable immigration associations such as AILA. Next, check state bar disciplinary records and require a clean history. Understand the fee structure, scope of work, and the fact that no attorney can guarantee a visa approval. Prioritize experience that matches your specific issues, such as prior denials or waiver work. Finally, do not fixate on location since immigration law is federal. Seek competence and fit over proximity. With due diligence in mind, let's examine the cost-benefit framing. Think in terms of cost versus value. For clean cases, invest time in preparation rather than paying unnecessary fees. For complicated cases, view legal fees as insurance against long-term harm, especially when inadmissibility or waivers may be involved. Request a clear flat fee structure with a written scope of work. Be cautious of any guarantees, as no one can control outcomes. Finally, weigh the opportunity costs of delays, repeated refusals, or potential inadmissibility against the cost of expert counsel. Before we summarize, let's include an important disclaimer. Disclaimer: this content is for general educational purposes only and is not legal advice. Immigration laws, policies, and adjudication standards can change over time and vary by circumstance. You should consult a qualified immigration attorney about your specific situation, especially if any red flags such as prior denials, overstays, criminal history, medical issues, or complex finances apply. Now, let's consolidate everything we covered into a concise summary and final checklist. Here is the final checklist and summary. First, Clean B-2 cases can often be handled without a lawyer if you prepare meticulously. Second, your main task is proving non-immigrant intent through strong and documentable ties. Third, hire counsel if any red flags exist. Fourth, vet attorneys carefully by credentials, disciplinary history, relevant expertise, and fee clarity. Finally, remember that no one can guarantee outcomes. Your consistency and credibility are crucial. To close, we will add one more visual to reinforce the journey from preparation to decision before our final message. This final flowchart reinforces the end-to-end process, starting with gathering tie documents, completing the DS-160, assembling financial proof, and preparing for the interview leads to the interview and then the decision. If refused under 214B, the path branches to strengthening ties, reassessing weaknesses, and reapplying when appropriate. At several points, the presence of red flags should route to consulting an attorney for specialized guidance. With the process map in mind, let's wrap up with a thank you and a call to action. Thank you for watching. If you found this helpful, please like the video, share it with your family, and subscribe for more practical immigration guides. Leave your questions or topic requests in the comments, and we may cover them in a future episode.